Welcome friends, today we will discuss Article 14 of Indian Constitution in detail. Let's start the video. First of all, Article 14 is a part of fundamental right. Then the first question which will come in your mind, so what exactly are the fundamental rights? Fundamental rights are discussed under Part 3 of Indian Constitution under Article 12 to 35. Now the source of fundamental right is USA. Then comes the next question in your mind, so why fundamental rights are essential? For fullest development of any individual, you require certain rights. These rights, we call it as fundamental right. The development may be material, spiritual, or any other development. And these fundamental rights are guaranteed by Constitution. What do you mean by this? If any of your fundamental right, which is given under Part 3 of Indian Constitution, is violated, citizen can directly approach to the highest court of land, that is Supreme Court, under Article 32, and Supreme Court can issue certain writs. That itself means fundamental rights are too much important for individual. And fundamental rights, because of them, it is possible to have political democracy in a country. It facilitates that aspect. So that shows the relevance of fundamental right. And in our constitution, fundamental rights are discussed in a detailed manner. Then comes the next question. So does that mean fundamental rights are absolute? Answer is no. No fundamental right is absolute, and it cannot be. Why? Because no doubt a citizen right should be important, and as we have discussed that these rights are essential for fullest development. But don't you think whenever there is a society versus individual interest, society interest shall prevail? And that's the reason certain reasonable restrictions are always there on fundamental right. Now, whether the restrictions are reasonable or not, if there's any question, you can approach to the court, and court is a final authority to decide that. Now, I hope the basic of fundamental rights are clear, and few fundamental rights are available to citizen and others are available to all. Now, if this part is clear, let us go ahead. Fundamental rights are divided into 6 parts. Earlier it was 7 parts. Right to equality under Article 14 to 18, then right to freedom under Article 19 to 22, then right against exploitation under Article 23-24, then right to religion Article 25 to 28, then cultural and minority rights under Article 29 and 30, and last is right to constitutional remedy Article 32. One more right was available, right to property, but by 44th Amendment Act 1978, this right is now no more available. Now this right is only a legal right available under Article 300 capital A of Indian Constitution. Now let's back to our topic, today's topic, that is Article 14. Article 14 is very important from prelims, mains as well as interview point of view. Most of the time we see question on Article 14. Now let us see what exactly is Article 14. Article 14 says, state shall not deny any person equality before the law and equal protection of laws within the territory of India. Please listen carefully. It says that state shall not deny to any person, they have used the word. Persons means the right is available to only citizens. No, it is available to even foreigners also. Not only that, persons means even legal entities also possible. That means this right is available to company, corporation, society and so on. That clearly shows Article 14 is available to all. It's not only limited to citizen. I hope the meaning of the word person is clear. Now let's go back. It says that state shall not deny, so state cannot deny any person equality before the law and equal protection of, it is laws, it is plural, and here it is singular. What is the difference? We will see. Both are same or both are opposite to each other or both are complementary to each other. At the end of the video, you will be able to answer all those questions. So please watch the video till the end. Now, first part. Equality before the law. Now, equality before law, it's a negative concept. It's a negative concept borrowed from UK. Why negative? That also we will discuss. It clearly says that there is an absence of any special privilege or favor to any person. So there won't be any special privileges. And there will be equal subjection of all person to the ordinary law of the land. And no person is above the law. What do you mean by that? Whether it is rich or poor, all are going to be treated in equal manner. I repeat, whether it is rich, poor, whether it is any other person, going to be treated in an equal manner. Whether it is a government official, non-government official, they are going to be treated equally. There will be absence of special privileges. Means state cannot discriminate. State cannot do any favors, and that is the way it is normally say that it is in negative connotation. Now, rule of law, this concept, we normally say it is propounded by A.C. Dicey, a British jurist. What exactly he says? He says things in three parts. First, rule of law means absence of any arbitrary power. Means a person can be punished only for breach of law. You can't punish any individual on your whims. So you can punish any individual, but only for breach of law, not for other things. Equality before the law, it says that equal subjection of all citizens to the ordinary law of the land, and primacy of the rights of individual. Out of these three, two are available in Indian Constitution also. Then comes the next question. So in a simple language, if I want to discuss rule of law, don't you think we can say that rule of law means no one is above law, everyone is equal in the eyes of law, and there cannot be any special treatment to anyone. Whether it is a rich, poor, all are going to be subjected to the same law of the land. Then comes the next question. So rule of law, is it a part of basic feature of Constitution? The answer is yes. But before that, you may ask, sir, what exactly is a basic feature? In 1973 landmark judgment of Keshwanand Bharti versus State of Kerala, Supreme Court said that there are certain features of Indian Constitution which cannot be changed, and these features we call it as basic features. Now, which are those features? Are they defined? Answer is no. Supreme Court has said that case by case basis those can be decided. And in one of the cases, they say that even rule of law is a part of a basic feature of Constitution. That means Parliament have right to amend the Constitution, any part including fundamental right. But they can't amend the basic feature. And now rule of law is a part of basic feature. So can it be changed? The answer is no. I hope it is clear. Then comes the next part. So what exactly is equal protection of the laws? Because here the word is laws, it is plural. And it is called as positive concept, which is borrowed from United States of America. What exactly is equal protection of the laws? The answer is here, don't you think, just under the name of equality, if we say that we are treating all equals, but treating equals in equal manner is good. But what about unequals? Do you think unequals should be treated equally or unequally? I will explain with one of the example. Now, look at this example. Now, don't you think all are watching a match, right? And as per the equality, we have given all enough space and enough area to watch the match. So all are treated in an equal manner. But do you think all of them are able to watch the match? Answer is no. Number 1 can, number 2 can, but number 3, no, it is not possible. So here equality is there. But do you think justice is there? Answer is no. And that's the reason what we are supposed to do. We are supposed to take something from here and give it to the third person. And then you can achieve this justice. So equality is important, no doubt about it. But justice is also important, and two things are not opposite to each other. We want to achieve equality, but with justice it should be there. So don't you think there are certain positive discrimination, or normally what we call as affirmative actions are necessary? Means what? Here, if required, state can interfere. state can interfere and state can go for certain affirmative actions. I can give you example. Say for example, in India we have reservations. Now reservation is also one of the positive discrimination or affirmative action. Is it essential? The answer is yes. Don't you think we have reservation for SC, for ST, for OBC, and now there is a new class that is economically weaker section. So don't you think here all are different? So all should be treated in equal manner? No. Within a group, they should be treated in an equal manner. Now, why reservation is essential? Because of history of injustice of thousands of years. So don't you think by giving certain additional things, that by interfering state into certain things, even we can have a level playing field for all, and that gives the benefits to everyone, and that is the relevance of reservation, and that's the reason it is required. So don't you think here state if want can interfere, and this is what known as positive discrimination. So under equal protection of the laws, if state interfere in your rights, still it is okay. The law cannot be declared as invalid because it violates equality. Listen carefully, equal should be treated in an equal manner. But what about unequals? And these examples make it quite clear that equality should be there but with justice. I hope both the examples are quite clear. Then comes the next question. So are there any exceptions for equality, or Article 14 is absolute right as we had discussed? Listen carefully. As I earlier said that no fundamental right is absolute. There are certain restrictions, and restrictions are necessary. Yes, reasonable restrictions are required. So here also certain exceptions are there. Article 14 is also not absolute. Some exceptions are there. We will discuss few exceptions of it. Article 361. Its exception regarding what? President of India and Governor. Now, in their official capacity, whatever they have taken, whatever decisions they are taking, they cannot be questioned in any court of law. Now, you may say, so why? Because if you read the constitution clearly, don't you think whether it is president or governor, they always act on the advice of council of ministers, except some cases. So the way in the Britain part, king used to do no wrong. Here also, president, when he is in office, he cannot be questioned for any decision he has taken in his official capacity. This is the first one. Second, Article 105 and 194. Member of Parliament, whatever they say on the floor of the House or vote, that cannot be questioned in any court of law. So even they also enjoy certain immunity. Then comes the Article 31, capital C it is. That is, it's related to DPSP. The statement normally goes where Article 31C comes in, Article 14 goes out. Means what? If you are framing any law on the basis of DPSP, all provisions, answer is no. Only 39 clause B and 39 clause C. If you are making any law by using the provisions of Article 39 clause B or clause C, and if it is violating Article 14, then that law cannot be declared as null and void. Then you may say, so why this special privilege? Listen carefully. Article 39 clause B and clause C, what exactly they say? They say that the material resources of the country should be utilized in such a manner that larger public good should be served. So if it is in the interest of a public good, then it should be allowed. And second thing, it says that economic or resources concentration should not be in the hands of few people. That means monopoly should be avoided. So if such a good provisions are there, and if you are making any law on those provisions, and if it is violating Article 14, then it should be declared null and void. Answer is no, and that's the reason it is says where Article 31C comes in, Article 14 goes out. Similarly, foreign sovereigns, diplomats, ambassador, even United Nations and its agency, they also enjoy certain immunities. So these are the exceptions for Article 14. Then comes the conclusion. So equality before law and equal protection of law, both are opposite to each other's? Answer is no. Both combine, they aim to have equality of legal status, opportunity and justice. That means both are essential. Please listen carefully. Under Article 14, reasonable classification is allowed, but the classification should be fair and reasonable. In that case only it is allowed, else Supreme Court can struck down that classification. Now, if you have gone through this video clearly, in the exam they may ask you a question, discuss equality before law and equal protection of laws. I hope you can answer this question after watching this video in detail. And second question, discuss exceptions to equality, what we have discussed just now. So these questions may be there in the mains or interview. Then comes the next. So what about prelims? What kind of questions can be there in prelims? Let us see one example. Article 14 of Indian Constitution, what it discuss? The freedom of speech, right to privacy, right to religion, or equality before law and equal protection under law. If you have watched this video carefully, I hope you can answer these questions very well. If you know the answer, please write down in the comment box. Thank you very much.